My name is Hillary Johns, and today it is my pleasure to introduce three of the best trial lawyers and consultants in the business. And first, we have Lori Kozlansky, PhD. She is an expert jury consultant with over 43 years of experience, holding a doctorate in cognitive psychology and a master's in linguistics from Columbia University. She specializes in jury selection, case themes, witness preparation, and trial strategy, having consulted on more than 1,200 civil and criminal jury trials nationwide across a broad range of legal matters. Dr. Kozlansky is sought-after speaker and published author who has been recognized by Legal Times, which voted her the #1 jury consulting practice in the country for 4 years in a row. Jay Spillane is a founding shareholder of Spillane Trial Group, a business trial firm representing private companies and individuals in high-stakes litigation for over 3 decades, with clients ranging from entertainment and sports personalities such as Robert Redford, Harold Ramis, Kelly Slater, and Ken Steffes, to corporations and executives in matters involving intellectual property, technology, real estate, and corporate control. He is known for distilling complex business disputes to the ethical principles at their core, and an approach that drives favorable settlements and strong trial results. Spillane also handles all levels of appellate work, including his representation of CC Bill LLC and CWI LLC in Perfect 10 Inc. versus CC Bill LLC, one of the most widely cited cases on internet services provider liability for alleging infringing content hosted on client websites. He is also American member of the invitation-only American Board of Trial Advocates. Neville L. Johnson is a senior partner at Johnson & Johnson. Neville graduated Phi Beta Kappa from the University of California, Berkeley, 1971. He received his law degree from Southwestern Law School, 75, graduating at the top of his class. He has tried over 28 civil jury trials and over 70 civil trials, arbitrations without a jury. He is a member of the invitation-only American Board of Trial Advocates and is on the Board of Governors of the Consumer Attorneys of Los Angeles since 2005, the Board of Directors of the National Organization Public Justice, and on the Board of Governors of the Beverly Hills Bar Association, 2013 to 2015, 2020 to 2022. Johnson is a longtime member of the invitation-only Los Angeles Copyright Society and the Board of the California Society of Entertainment Lawyers. And now let's get started.
Thank you, Hillary. I'll jump right in. Welcome, everyone, and thank you for joining us. I'm Lori Kozlansky, and I consult on all types of civil and criminal cases, and a very common question really is, how do you get jurors' attention? How do you keep their attention? And that has become a challenge from the get-go that is only getting harder with all the different changes in our lives. To start with, I'm going to state that this is about attention, so I'm going to start with ADD, which is a pretty common moniker for attention deficit disorder, but today, which is currently now called ADHD, I'm going to call it ADD, how to attract attention, not detract attention or distract attention. So those are kind of the themes right in my wheelhouse. We're now facing people of all different generations in the jury pool. In fact, there are approximately 5 generations that can serve right now from the age of 18 all the way up to over 80 that cover the gamut of different generations, and they speak a different language from one another. So one of the things I say is, well, before you get their attention, you're going to have to know what is it that they pay attention to and what don't they pay attention to. An expression of millennials today, is this expression called "just put the fries in the bag, bro." Not meaning that it's an insult to people who work lower level jobs at minimum wage, but it means, there's that person sitting at the warmer with the fries and the scooper and the bag, but they're not putting the bag with the fries together. And usually fast food, people want things to be fast. Well, that's pretty much where we are right now in terms of the jury pool, especially the younger jury pool. It also is a different language, as I mentioned. So, for example, what does it mean? Put the fries in the bag? Well, we used to say things like land the plane or get to the point. And that's silent generation and boomers. Millennials and Gen Z, however, don't speak that way. So the first issue is, what are some of the blocks to attention that get in the way of getting attention before you can keep it? And why don't people pay attention? Well, one might be because they have negative beliefs. For example, they might feel negatively, especially these days, against corporations or banks or insurance companies or certain groups. There might be counterintuitive law. So, for example, you may have an oral contract, which we're going to speak about a little bit later today as well. They may think oral contracts don't have any meaning if it's not in writing, especially for a lot of money. They may, for example, think that things like at will can't possibly be true, that you can fire someone for no reason or a reason or any reason as long as it's not discriminatory. Jurors don't believe that. Or it might be fiduciary duty. It's counterintuitive to think that you're supposed to put somebody else's interest ahead of your own. So before you actually get to persuading them, you have to understand what are the blocks that might be in the way that would stop them from listening and paying attention. In addition, they might be too young or too old to pay attention or remember. They have different reasons for not being able to pay attention. Younger people these days are really used to getting a lot of adrenaline hits from their interaction with immediate gratification. I used to say there was delayed gratification and then it became instant. Now it's instantaneous. And so they're used to really fast reactions and fast information, and it's hard for them to pay attention if they don't get that. Older people have other challenges. And then in general, people may not care. So if you don't care to pay attention, you're going to pay attention. You're thinking about your dry cleaning or what you're having for dinner or other things that are more important to you. Or you might care too much if you're a juror that has certain issues on your mind and agendas, and that really will hurt one of the parties and help the other. So how do you deal with that? Well, the first job you have is to try to remove jurors that are bad for you, whichever side you may be on. You have to find out who rejects your position. You do that through asking questions, of course, in voir dire. Not in a shotgun approach, because that's really not useful. You need apples to apples comparisons to understand what are the real issues that are problematic in your case and the kinds of jurors that will reject it. And what are the targeted questions if you can only ask a few of everyone. Social media today is really important because people present a lot of information about themselves, except for those few that act like Banksy and don't present anything, who are also people of concern. And thirdly, we have the ability now using AI with a sufficient amount of time, which is not a lot, to actually do a very fast scrape of social media and public information about people to find out things like voting records and other things, which turn out to be very important in predicting juror orientation to a verdict. And then you have to find out who can't attend, understand, or recall the information. And then you ideally want to remove as many of them as you can for cause. You can't control it, but you can certainly attempt it. And so by showing that they just cannot constitutionally remember or pay attention, that should be a reason not to have someone serve on a jury. Unless, of course, it's in your benefit for them to miss information. And sometimes that happens. In terms of dealing with counterintuitive law and negative beliefs, you have to, of course, disabuse people of that before you get into the case in chief. So, for example, in the 1993 case involving the World Trade Center bombing, the law required the jury to find that the owners of the building had more responsibility than the terrorist for the bombing, which, of course, makes no sense to your average person in Southern District of New York. And so we had to reframe that as not being about the terrorist responsibility to tenants, but a landlord's responsibility to tenants. So by being able to reframe that in terms of a concept that people could relate to, it made it easier to get past that obstacle to attention and credibility. In terms of non-binding contracts being oral, of course, that's something you need to refer to the law and other things that we'll show you. Negative beliefs about corporations, for example, being greedy. If you're a defendant defending a corporation, what you want to be able to show is not to make them change their mind about corporations being greedy, because that's not going to happen. Instead, what you can do is show, if possible, that actually what the plaintiff said happened would have cost more money than what actually happened. Had we done the right thing, for example, as a corporation, which we did allegedly for the defendant, how that actually was less expensive than the wrong thing. And so it's about knowing how to swim with the tide as opposed to against it. Other reasons that jurors don't pay attention down on the list is that very often attorneys will use too many words, not enough pictures, not enough themes and stories, and use language that no one else outside the courtroom would use, like notwithstanding. People on the street I've never heard say that. I've been to a lot of venues. I'm waiting for it to happen, but it hasn't happened. And also because they don't use enough visual support, graphics, and mixed media to garner attention. It's a very visual world we live in and a fast one. So next is who's on the jury. Now you've hopefully gotten rid of the worst of the ones that you can spot, and now you have people who are left. Well, as we said, there's a generational difference. We went from an early generation or generations who felt there was hierarchy and authority, I'm the boss, to, well, let's discuss and collab. Any of you who have children and grandchildren that fall into that category know what I'm talking about. It's a lot of collab talk. Also, though, there's an interesting shift in the analogies that they refer to. So in our parents' and grandparents' generations, they used a lot of sailing originally, like all hands on deck. They shifted then to sports analogies, to hit it out of the park or hit a home run or it's a Hail Mary. This generation, the newer generations, are now referring to things based on being gamers and video game metaphors. So, for example, there are terms that you may never have heard. Maybe you have. Things like you didn't step up to the plate is now things like, oh, well, they play like an NPC, a non-player character. It's fourth and long is now something like just reach the boss battle. They moved the goalpost. Now that is, they nerfed that feature. Nerf meaning to throttle down. And a silver bullet is now a one-shot, meaning that you can get rid of a player in a first-person shooter game, FPS. Not that I play them, but I know these things because of the work I do, that you could get rid of one player, particularly with one shot. It won't take multiple shots to knock them out. And other terms that we've talked about that come from the technology world. Also shifts are on the jury that you have to understand is who they think is an expert. Well, it used to be Dr. Spock, and then it became Dr. Google, then Dr. Reddit, then Dr. ChatGPT or Dr. Claude. And so while you may be relying on experts to get attention or to convince people, if they don't see that source anymore as a resource, it will not be persuasive. I can't tell you how many times I've had conversations with people who are lay people of a younger generation and explain, well, the reason I'm explaining the psychological concept and why it matters is that I have a PhD. And their reaction is, so what? Next is how to get and garner attention is to understand what is this case about for them? What do they need and expect from you? Very often we see attorneys come into a courtroom with statements like, well, they have to understand XYZ for us to win. And I don't like to start that way because they may not ever do whatever X is. So I like to know rather, what is it that we have to know in order to satisfy what they feel they need? They're not going to change for us. The only control we have is to modify what we're going to do for them. Why should they care? We know why we care, but why should they care? Are you addressing that? Why should they believe you? And how will the outcome impact them? So I would recommend that if you want to get their attention, speak to them as if you care about what their position is in the case or how it impacts them. Now, how do people get information these days, and how does that impact what they're paying attention to and what we have to pay attention to? Well, the older generation still sometimes gets its news from the news, meaning cable news or network news. Younger people, on the other hand, get it from social media, and we know this. Well, what does that look like? First thing is, it's going to look very visual.
The scenic palm tree-lined streets of Beverly Hills offer the perfect SoCal spot to snap some photos, but are sightseers taking the viral trend too far? Some local residents say they're sick of all the shutterbugs. Eyewitness News reporter Leanne Suter joining us live from one of the streets at the heart of this growing controversy. Leanne.
Mark, residents here along Cannon Drive say last weekend was the worst they've seen it. Absolute chaos, they say. So many visitors lining up in the middle of the street here just to get that perfect shot of those palm trees.
We got 1 photo shoot, 2 photo shoots, 3, 4.
So you get the idea. Well,
DC
that's the way that some of the older jurors may be getting information and paying attention. What I want you to know is that she's very animated, and there's switching of the visual scene very frequently and a real variety. Well, how do some of the younger people get information? Well, it's a combination of Instagram and TikTok. So upcoming FIFA, this is very common right now. So you see, again, now this has got music, it's got color, it's got a lot of motion in it, and it happens very quickly. And then on the right-hand side is actually the most, sorry, that's pretty funny. On the right-hand side, you have the most watched TikTok, which is really where a lot of course, people live right now. And what does that look like?
Like my costume? Yo, that's so cool. How are you doing that? Got a Nimbus 2000. Oh, I see.
And so that's what people are watching, are things that are very amusing, right? Amusing, visual, audio, changing, and so forth. And so if I have to tie it all up, the answer is think of the audience as very demanding. It's experience what we call the drop-down menu syndrome, which is really tailoring, seeing and hearing what it wants, when it wants, how it wants, and it has no control over that when it gets to the courtroom and the jury. And so at the end of the day, what they really want is for us to just put the fries in the bag. Thank you. Hillary?
I apologize. I thought you were just going to go in order. I think Jay is next, and he
All right.
come up. And you're welcome just to keep speaking, and if there, I'll field questions. Thank you.
Thank you.
Okay, thank you. Thank you, Hillary. It's very interesting, Lori. So I wanted to mention two cases that I think are exemplary, and they touch upon a number of aspects of the case I wanted to mention, including a pretrial mock jury, vetting the potential jury pool before they get in their seats, and also some visuals which I've actually used in closings that are easy to do. I've created them myself on PowerPoint that illustrate how I like to have my words, my themes, and color images all at the same time before the jury's connection. So the first exemplary case I wanted to mention was called Plan B versus Diversified Panel Systems. I represented the plaintiff. Plan B. Diversified Panel Systems manufactured insulated steel panels for customers. Think of grocery stores who use these things to create refrigerated spaces to keep the food fresh before it goes out on the shelves. My clients were in the cannabis grow room space, and they had realized that these insulated storage panels had huge advantages over the traditional, wood frame construction. They went to Diversified Panel Systems. They proposed a joint venture whereby my clients would introduce the defendants to the cannabis grow room space, which would increase the sales of these storage panels, which had not originally been built for this purpose, and they'd split the resulting net profits. Now, the problem was, in classic fashion, they just shook hands and went about doing business. And there was this document that got slow voted around, a draft term sheet that had this clause in there that said there will be no agreement unless until there's a signed writing, which never got signed. So one thing we did in the juror selection phase is there is an authorized judicial council foreign juror questionnaire, and you can also propose your own custom questions. And we did that here. Let me see if I can share this. So naturally, we wanted to know, we being the plaintiffs hoping for a multi-million-dollar verdict, we wanted to know if there's any jurors who are just going to negate the case because cannabis can be a divisive issue. So we had these questions. Do you believe working in the cannabis industry is morally or ethically wrong? Do you believe cannabis should be illegal? Basically wanted to find out people who were going to nullify the case because they just couldn't stand it was about cannabis. And we actually had quite a few people raise their hands and exit, which was a benefit to us because then we were only getting people who were willing to consider our case and weren't going to be troubled by the fact that it at least indirectly involved growing cannabis. And then I wanted to mention we had a mock jury where I presented Plan B's case. My colleague pretended to be the defense counsel. I played it very conservatively. I talked about how it had a handshake. I showed the jury this draft writing that there's no agreement until you have a signed writing. And then of course my colleague in the mock jury really beat me around the head with that document saying that disproves Spillane's case. He doesn't have a signed writing and he knows it. And then afterwards we passed out a little short sheet of jury instructions and we got huge feedback. The mock jury said I lost the case until they got the jury instructions that inform them that you can, California law supports an oral agreement, right? I mean, there's a lot of people who, there are some areas where legally, right, the contract has to be in a signed writing. So with that, I front loaded this in front of the jury. Within the first 3 minutes of my opening statement, I told the jurors the judge at the end is going to inform you that an oral agreement is enforceable under California law. And naturally, I drew an objection that was sustained. I said, forgive me, Your Honor, but I got that in front of them, right? And then in the closing, that I really needed to repeat that again. So let me see here. Yeah, okay, hang on. Go to the top here. And by the way, before I go to the slide view, I often do these things myself in PowerPoint. You can lay out the slide. If you can see on the upper right, there's a little designer button here. You click that, and it gives you, it reformats in interesting ways. You can, if there's a picture I want to put in, you can add that in. It's easy to do. I'm not a technician, and I did this myself. So this was the beyond the cover page. This was my first slide. And I wanted these words in these colors right in front of the jury's eyes to remind them under the principle of primacy, make sure you're saying your most important things first and last, that they could enforce an oral agreement. And we had good evidence that the parties had in fact performed and shared the net profits for a good while before the defendant claimed that it wasn't a deal for lack of the writing. I had this here, and again, I may be begging Lori's issue. I'm not sure if if this is an image that appeals to young people, but to me, you shake hands, you have my word. It's just an image I wanted to get in front of the jury respecting an oral contract. And here I quote that even the defendants said in their pleadings alleged that there was an oral agreement. So that was important to get to the jury in front. And at the very end, there was an exhibit I wanted to show them, which we used to great impact. I had the CEO of the defendant up on the stand. He had presented these financials showing what business they've been doing to the so-called cold storage industry, Trader Joe's or Ralph's, right, keeping the food cold, versus the so-called non-cold storage business, which was these warm room temperature cannabis grow rooms. So we had created this chart from boring looking financials, which wouldn't look visually interesting at all, but we created this chart including the color, which he validated on the stand. And you can see, just look at it, after my clients had introduced the cannabis market to them, it blew their revenue to the moon. And by 2022, it was 90% of their revenues. Instead of doing 3 million, they were doing 30 million. So that really showed the jury that what my clients had brought to the table really had impact. And we got a unanimous 8-figure verdict at the end. The other case I wanted to share, which is called the Skillern versus Grow case. I represented Dr. Kong, and it was a vascular surgery practice. There were 4 partners, and partners 3 and 4 were a little jealous and curious about why partner number 1 was consistently the highest biller in the surgery practice by far. So they decided to do a surreptitious review of his cases and came to the conclusion that he was spiking his revenues by subjecting patients to surgeries they didn't need, which is a very provocative accusation. They went to my client, Dr. Khan, who was number 2, pressed him to expel the first doctor, number 1. My client initially voted to do that under the pressure of being confronted with this finding. Later, acquired some doubts that his fellow partners had been dealing with him honestly. And in the discovery, we got these horrifying conversations in text where the parties who leveled this accusation were texting one another about being whistleblowers and making millions and buying the assets of the partnership at a fire sale after we blew them up. So the case involved days of just kind of mind-numbing testimony from these medical experts about whether or not, if you see this or see that in somebody's veins or arteries, whether you'd really subject them to the surgery. But from our standpoint, Dr. Kong was defending himself and asserted theories that this was inconsistent with the partnership agreement. I mean, you're supposed to be honest with your partners, right? And I just wanted to convey to the jury that they used this theme of subjecting patients to surgeries they don't need dishonestly for a craven purpose, for basically stabbing their partner in the back. So let me see. So after the opening slide here, I wanted to show my client and just have an image here of surgeons taking care of people. I mean, he and partner number 1 had built this vascular surgery practice that was saving lives throughout the Ventura and Santa Barbara area. And again, maybe I overused this image, but I wanted to convey this image to the jury that partners are honest with one another. They have duty to disclose important facts to one another, exercise their best business judgment, and be loyal to one another. Not parlay an accusation into financial gain. And here was this image here where I took a couple of the most heinous statements that were in these text chains. Let's blow this popsicle stand to the moon, which is in a text thread about the popsicle here was the vascular surgery partnership. And then there was cackling in a text thread about buying the assets of the partnership after they blew it up at a fire sale, which I thought was heinous. I had thought that there were some important lies. So I had this slide here. Now, I suppose this begs the question. Unfortunately, I'm old enough to remember having seen Pinocchio as a kid, and I'd be curious, Laura, if there's time later, if you think that 20-year-old would recognize this thematic. But of course, those of us who are old enough remember Pinocchio's nose growing every time he lied. So I wanted to give that visual next to my summation here about how I thought the parties who had initiated this problem weren't telling the truth. And then I got some of these texts in front of the jury. Let's see. And while I'm getting this up, let me just remark a moment about discovery of electronically stored information. I'm always amazed how people produce emails as a PDF image. Maybe it's faded. You need to get those in native format for among other reasons. You get the metadata, plus it just looks better on the screen. I've seen terrible productions of text threads where it's a little screen cap, or I've seen exports that read like a computer program, and you don't see the conversations like you see it on the phone, right? Where there's speech balloons and they're justified left and right, and the color. So here we actually went to court over this and forced the other side to export their text threads in a fashion that you could scroll through the whole thing, and the jury could see, the text thread rolling as though they were looking at it on their phone. So here was an exchange here where somebody's talking about my client as about being a terrible partner, and they say, let's leave and file a qui tam, which is a whistleblower action. And this is the reference to blowing this popsicle stand, namely the vascular surgery partnership to the moon. And then we had this text image here this was a reference to negotiating a deal to buy the assets of the practice at a fire sale after they'd blown it up. And towards the end, I wanted to have another image of people being honest with one another. I wanted to come up with an analogy for a relationship that's important, where people need to treat one another correctly. I said keeping a partnership together is like keeping a family together, and I found some, picture I grabbed on the internet of a husband and wife looking like they're having a difficult time in a therapy session to convey that image. And then finally I had some criticism of their damages, which I thought were non-existent. I came up with this cute little ghost thing again, which conveyed an image I wanted the jury to see. So these are just a couple of examples of how I used primacy and recency, saying the most important thing first, saying the most important thing last, removing jurors who are going to have an animus to my part of the case, and making sure that my words and themes are conveyed with images that I felt would capture the jury's visual attention and keep them awake and interested while I was conveying orally what I thought the evidence had shown. So, and again, we got a unanimous verdict in favor of Dr. Kong after making that presentation. So thanks so much, and I'll turn the microphone over to Neville.
Hi, everybody. Jury selection is the most important part of a case. These are your judges. You need to win them over. First thing to be considering is that you are, am I on the screen? Okay. First thing you need to be aware of is that you are on duty 2 miles from the courthouse. So be careful. Whether it's in the cafeteria or the hallway, they're looking at you. They're looking at how you're dressing, how you're interacting with everybody. I know a friend of mine who's a big hitter on his first day as having a jury trial, showed up in his Porsche. He was late, and he didn't know it, but he cut off a juror, and somebody saw that, and he lost the case. And when he talked to the jurors afterwards, they said, "You cut me off, and I saw you do it." I saw the public defender of the city of Chicago give a talk on jury instructions. He said, Most important thing is to get the jury to like you. That's the most important thing. I saw another big hitter who he just said, I want to bond with the jury. I have a friend of mine who's a very successful lawyer. And he says, I went to the Jerry Spence school. I totally follow that. And we spent 5 days in psychodrama, whatever it is. But I said, how do you do this? And he says, I become one with these people. I learn who they are, and I can feel them. No joking. It's not a time for that. What you want to do is learn their names if you can on the jury. So you can say, well, Mr. Bennett, Mr. Smith, whatever it is, do you agree with Ms. Jones, what she has to say? That shows that you're on top of it, although it's very difficult. You know, the way they're picking juries these days is you have 75 people and you're supposed to query them all at the same time. Don't be flashy. No jewelry, no monogram shirts. Wear white shirts if you can. Use visuals. I've seen the Pinocchio example in the past. You want to use videotape when you can. There's nothing more powerful than to show a witness 20 times on video saying, I don't recall. And then you say, what's the number one way people lie? They don't recall. And you've already asked them the question, you remember things that are important in your life? And was this important? Oh, you don't recall? Okay. You want to use video to impeach. There's nothing more powerful than asking a witness a question saying, oh, really? And then boom, you hit them with that. You do that 2 times, that witness is blown out of the water. Jury questionnaires are very useful if the court will let you do it. We use jury consultants, and they're very, very helpful. We recommend them because they can see things that you're not going to pick up as well. We have used mock juries, and you can pay plenty to go to an office and where they'll have a mock courtroom. We use Craigslist and pay them $50 and give them lunch. They'll spend 3 or 4 hours with you and help you figure out what it's going to take to get your ball over the plate. Voir dire. Absolutely use artificial intelligence. I was supposed to start a trial 2 weeks ago. It got continued, but my friend Claude, I said, here's what the complaint is. Here's some of the issues in the case. Here's the kinds of people that I'm expecting to have. And I got 90 questions, 70 of which were perfect overall. You want to find out, your key is to find out their biases. Anybody who's biased against your jury, you want them off. And how do you do that? You get them talking amongst themselves and you tell them there's no wrong answer. How many people think there's too many trials, too many cases, et cetera? And you raise your hand along with them as well. And you talk to them in an interesting, nice way, like it's a talk show or whatever it may be, to say, oh, okay, I agree, or I understand. You don't say I agree, say I understand. And who agrees with what so-and-so has said in this particular case? I've seen one lawyer I know, he just says, I want brutal honesty out of you people. If you don't like me, you tell me. And I actually did that in a trial, and they said, yeah, I don't like you so much. I won a lot of money. And I think I got rid of that juror. But one of the other questions is, do you believe that people who are bringing lawsuits start behind the starting line if this was a race? In other words, they have to catch up for other people. Can you award substantial damages if the facts and law warrant them? I always ask, what are your hobbies? What do you do for fun? What programs do you watch? What do you subscribe to? Is there something I should know about you that you haven't revealed? Is there anything about anybody in this courtroom or this case that bothers you? Do you know about similar cases? Have you been involved in anything like that? Types of jurors. Everybody says, and I don't know how scientific it is, but we don't want accountants, engineers, and scientists because they don't have as big a heart as the rest of the public. Others have said, I don't want any immigrants. People from other countries are not used to awarding large amounts of money. And I want to make that clear at the very beginning. If my facts and law show you that it could be millions of dollars, are you willing to award that? Are you willing to award punitive damages overall? If they don't want to be on the jury, I don't want them on either. I was picking a juror one time, and the second day of jury selections, this dude stands up in the middle and says, "Why am I still here?" Okay, you gotta go. The lawyer, and we heard this from our jury consultant, the lawyer is not the star, the client is. The lawyer is calm and organized, but he can be passionate in closing. I have a friend of mine, a big hitter. Somebody once made a motion in limine that said, Your Honor, tell him he's not allowed to cry in closing argument. I know some lawyers who take improv classes. There's an improv class available for lawyers to help you during trial overall. I highly recommend some seminars that you attend where you can learn other, I'm not going to call them tricks of the trade, other techniques. Make sure that in your opening statement, you say fundamentally what the case is about, because that's a rule that you have to do that. And it happened to me once. I was not aware of the rule. I had to go back and repeat my opening statement, and it didn't make me look so good. Another thing is that I did a jury trial one time, and we won, but the juror said, we're not stupid. You don't have to say the same thing 5 times over and over again. So that's kind of the bottom line for me is what I'm saying of my tips overall. And I guess now we can have an agreement to talk amongst ourselves or answer questions if people have any that they want to ask.
I do have a few questions that I would like to add, and since I'm so fortunate to have the 3 of you here, I have a list, and I don't think we have any current ones. How do you approach? I didn't work for never worked for the public defender. I didn't work for the public defender DA, but I was on the court appointed attorney defense panel because we did a lot of criminal defense early on in my career, and we had fast trials where I know Jay explained where he was successful in a trial, but it was a lot of testimony. And Neville, I know you've been involved as Lori, you certainly have. How do you capture a juror's attention and maintain it quickly when you have to grab it when the trials, we've all seen these situations, judges like, get a jury in here now, we're going to pick a jury. I don't want this case to drag out all week. I've got a full calendar. Does your approach change when you're dealing with a fast trial as opposed to a long trial, besides the obvious?
I always want to keep it moving as fast as possible. I mean, people get bored and they get angry, and you don't want to keep them waiting around at all. And I want to say one other thing, which is why it's helpful to have jury consultants, et cetera. I mean, I almost got burned. I won a big case, but the 20-year-old, 2 20-year-olds, they were going to stick it to me. I won I think it was 9-3 overall, and they were not on my side overall. So don't think that just because they're college students or whatever, that they're liberal or anything like that. You can't always tell. And the other thing is don't it's for cause is what it's all about. I'm trying to get rid of people for cause. And sometimes a jury selection can go on for 4 days and you get rid of 53 people overall. And one other thing I want to say is respect at all times for the court, the clerks, the jurors, opposing counsel, your client, etc. At all times. And you don't want to be arguing in front of the jury with opposing counsel. Judges hate that. You want to win, but you need to control your emotion overall so that you're not over the top. I mean, you're supposed to be articulate and measured is the goal. But you can, as I said, in closing argument, no problem. Be passionate away all you can. And people always say, get away from that podium, get in front of the jury, have your jacket open, and there you are connecting with them, looking them in the eye overall.
Hillary, there's a phenomenon I try to focus on, which is trial estimates, right? I mean, yes, I want to get my point out there, get focused, show my images, get my main thing, sit down. Um, what I find so many practitioners don't focus on is I hear these trial estimates, and they just seem totally unrealistic. And in Los Angeles Superior Court, unless you get in the complex department where there's no morning calendar, if you're in one of the departments where there's a morning calendar, you're going to get 4.25, 4.5 hours of testimony, soaking wet in one day, right? And then it's what I see, especially if I get colleagues maybe at bigger firms who haven't tried as many cases, they list 400 exhibits, and they've given us 6 or 7 day trial estimate. And then if you break it down, some of the judges require a list of the witnesses with, how many hours you're going to go on cross direct and direct, cross and redirect. They've estimated 100 hours of testimony. So it's going to take us a month to do that. So I often have to fight against unrealistic trial estimates. In the vascular surgery case, that judge handed off her morning calendar. She took the kind of the biggest courtroom in the Ventura County Court, and so we were getting closer to 6.5, 7 hours, which compressed it. But we had a hard time keeping the jury's attention there because there was so much medical testimony that was important, but a little mind-numbing, which is when I just try to get up there and say, look, I don't know what you think about the medical testimony, but you got to be honest with your partners, not stab them in the back. Have my little punch points during a very long trial.
Smart. I would add one quick thing to that, Hillary, which is, Pixar and trailers for movies do exactly what you're asking, right? So how do you get somebody's attention quickly and it motivate them to be there for the longer story, right? I would say look into Pixar and how it goes about storytelling. You can find it online. It's free. They obviously do that very well. Ken Burns, the people do it very well. So you want to be able to get their attention quickly. You want to be able to tell a story. You don't want just to ram a bunch of facts down their throats. And what Jason is very important also, which is you want to be thematic in terms of there's all this talk and detail, but here's the point. And so what you want to do is create audio tabs of the chapters to say, here's where we're going next. This is what we're doing. This is why I'm telling you. One of the articles that I'm sharing with the audience and they're welcome to see is called, Why Are You Telling Me That? It's the only documentary, a trial is the only documentary that doesn't give you the real title until it's over. So, you're getting all these facts and no one puts the story together for you typically until it's kind of too late. And so you want to be able to front that so that you can motivate them into paying attention to it, whether it's short or long.
Another issue that you have is how much time are you going to have? And you should have as much as you want, but some judges say, I'm going to give you an hour. And that's the way it is. And how about federal court where you don't get to pick, you don't get voir dire, although some judges will allow you to do it. So what are you doing then? You're saying, can I have jury questionnaire? Can you ask them these questions, please, Your Honor? I need to know overall. But I mean, they can do jury selection. I mean, I've had it in like an hour.
Yeah.
They just basically ask your name and where do you live? Thanks a lot. Goodbye. And again, of course, I echo what people have been saying is themes. You really should be developing a theme all the way through to the time when it's time to bring it home overall. But the bottom line is don't bore the jury and just, get to the point.
And 2 follow-up questions. Don't bore the jury. Perfect segue. Lori, I know all of you are great. Jay and Neville are both great at this, and Lori, you're a pro too. Observing the jury, I've seen this happen. I've seen it in hearings. I've seen it in trials that I've observed. And I've seen it when I've been in trials, you're losing the jury. We've all seen the situation where the judge is really annoyed and you can tell they're annoyed and the person's not reading the room. And we've seen attorneys go in and spit up all this information and the jury could care less. What are some of the tips or practices that all of you use to observe the jury when you're in trial? I'm not talking about voir dire or things like that, or you look at them and you go, Yeah, they're not liking this. Sometimes you can tell. It, like Neville mentioned.
Well, if they're sleeping, you got a problem. But I had a judge in one case that I had, and it was a long trial, like 6 weeks. And the judge, and we were creaming a witness. And the judge, after the day ended, said, I really don't think you ought to continue with this witness anymore. The jury has got it overall. So that's, I think, a tendency is, you wanted to throw everything in, but you don't need to. It's just make your point and move on. If you can destroy the credibility of a witness in one or two questions, why spend 10?
I'm always, I've seen lawyers in court examine a witness while seated looking at their laptop on which they have their questions. I've seen lawyers ask questions and they're turning their backs on the jury. When the other side is grilling my witnesses or putting theirs on, I like to turn and look at the jury just to see, is the jury nodding? Are they shaking their heads? Are they falling asleep? And if I'm examining witness, I always go to the podium. I always ask the judge, what is the territory within which I can move without being admonished by Your Honor? And the medical thing is, okay, you have to be able to touch the podium. So, so I've got like one fingertip on the podium, and I ask I'm looking at the witness for the question, but then when it's the answer, I turn to the jury sometimes to see how they're reacting, make eye contact. It just makes it a little more, you're getting a little more chance to get people's reactions than if you're just, sitting there with your outline going through all your questions like this, and you're just not experiencing what's happening in the room.
Okay, a couple of other things you can do. One is I find that the way that questions, whether it's direct or cross, get asked is not the way anybody speaks in real life. Typically, it's sort of depot speak. So the first thing I would say is don't do that. Speak like a person that's having a conversation, whether it's friendly or hostile or whatever it may be, and don't forget to use intonation. So, really, did that happen? You want to be able to get people to pay attention because it's the way people actually communicate. That's one thing. The second thing is shake up some of the media. Don't just use blow-ups of documents. Use other types of media. Make sure that you're using different types of visuals. Thirdly, if it's a very important witness, good or bad, fill the courtroom. Let the signal be that this is important to pay attention to. So bring an audience in on your side, on the bride side, so to speak. On the other hand, if it's really someone you don't want them to pay attention to because it's very damaging or maybe not such a good witness, maybe empty your people out of the courtroom. Like, don't worry about this. You can take a nap now. So you can send signals to people to pay attention or not pay attention, and absolutely be able to shift on your feet. If you see that you're losing them, there's no point to keep going in the same way that you're doing it.
Which brings me to my next question. I'm either a war story or a time or a tactic that you've used when sometimes, I've had this in hearings and trials, and a lot of lawyers have, what you're doing is not working. Either it's the graphics are not persuasive and you're putting these people to sleep, you've lost them, you have other options. Sometimes if you have no other choice, there's like, I know, Jay, you were discussing, there was a lot of medical testimony. You had to get that in, and you very clearly stated that you could, get the soundbite in and get the point of crystallize the point that you were trying to make. But sometimes, hearings certainly, and in trials, what you're doing is not working. And you may have to change course, maybe not throw out everything, but can you think of times that's happened and how you handled it, or tips to manage that if you have to make a course correction that, these things happen?
I'll say this, it happened to me one time where my witness I had brought his notes with him to the stand, and the opposing counsel was able to see them. And this was the questions we were going to go over. I wasn't too happy about that. So leave it in the seat when your witness is there.
That's a good point. I've had that happen to me.
Also, I'll tell you, another time I had a client, one of my earlier cases, and he got up in the middle of his testimony and like pointed at the defendant and said, you guys cheated me. It was like to piss the judge off. He was showboating is what he was doing. Now, I had no idea he was going to do that, but you got to learn to keep them under control overall. Although there was an amusing moment one time when I asked my client on the stand, why did you call so-and-so a rodent? And he said, just look at him.
Best visual you could get.
Or another time I had a guy who was an expert witness on the valuation of something, and the opposing counsel said, have you been paid yet by Mr. Johnson? No. How do you know you're going to get paid? And the witness said, how do you know you're going to get paid? So anyway, there is humor occasionally.
Jay?
I mean,
Go ahead.
I've trimmed my witness list. Said, I think we got this point. Maybe we'll drop a witness I was thinking of bringing. I've trimmed or adjusted, my outline, particularly if we get a lunch break or a morning or afternoon recess. Say, why don't we scratch this topic and just move to the last point? So I've tried to make those real-time adjustments. And in some cases, there's just not much you can do. I actually, my side in the vascular surgery case my client wasn't dependent on whether the surgeries were or weren't necessary, but sometimes, I don't know, sometimes you just you got to get through a lot of material. My impression was the jury was to get lost on this, which is why I wanted to stay with just simple themes. If your partner, you got to be honest, you got to be true, and you don't stab your partners in the back for financial gain.
Lori?
I would say, I mean, I agree with all that. I think, what I say to clients is, I think of juror time, like juror years, like dog years, like a minute of an attorney's lifetime feels like 7 out of the jurors. So you really have to understand that while you may think it's all pearls, they don't. So in any case, that's going to be the case, that they feel that their time is not necessarily being used optimally, that a lot of time is wasted, it's disorganized. So first of all, certainly be organized, be prepared. They don't want to see you shuffling your papers up at the podium, things of that nature. But in addition, what I recommend is it's not working, and that can happen to anybody for a variety of reasons, is I think for each key witness, you should have one summary graphic that's sort of the kill shot that says, here's why I'm here. Here's the point that I'm going to be making with this person, whether it's affirmative or defensive. And so that if you need to, almost at any time, you can jump to that and just go, so does this summarize, your testimony or your position or what you've, testified to? And if it's your witnesses, you want to make sure that all of your witnesses know their summary slide. And then, of course, that your opposing don't. But that's always a go-to, which is like, let's cut to the chase type of slide.
What about the classic situation where either you don't like your client or your client is not likable? We've all had these. Lori's smiling. Lori, why don't you start us off there?
Oh, no. Well, I'm not a fan of saying to the jury, look, you don't have to like my client, but I don't think that's a really good way to go. I think what you want to be able to do is talk about the values that matter, that do align with where your client is at. But what I often do if a client is not likable is I will tell them that. I'm very often hired to be a bad cop. Okay. It's easier for me than the advocate who's got to be there kind of as a cheerleader. I don't. I'm there and I'm a truth teller, and I have, some psychological training to be able to deliver a poison pill, which is, look, if I don't like you, and I get paid a lot more than the jury, why would they be motivated to like you? So I want to align with them to let them understand, first of all, what they do that is not likable, to see what it is that they can do to deal with that. Because if they have ego, and they typically do, see that they're working against their own best interest. And I work with a lot of celebrities, and that's an issue there too. And I can tell you that research shows that likability is 50% of credibility, so that they can actually shoot themselves in the foot very easily if they don't take care of the fact that they're not being likable. And there's a lot of studies about what makes people likable and unlikable, but most of people have a good gut about it.
Yeah, when it comes to that also is you've gone through the testimony with your witnesses before, so they know what's coming. And you know, the kinds of answers that you're looking for, you know, that are truthful overall.
Yeah.
Brevity, conciseness, organization.
I had a pro bono case where I represented a fellow who was a civil commitment for pedophilia, which is loathsome, of course. And we had a Fourth Amendment or Section whatever it's called case where they were going to search him, and he wanted to be searched by a psychiatric technician who was familiar with his ailment, but instead the guard slams him to the hot pavement, 100-degree heat, and beats him up, and he was all injured. So I got an eliminate ruling from the judge saying that the only reference people could make is that he was committed for being a danger to himself or society. So the jury didn't know his particular ailment. And I just told him, look, maybe you're glad that my client isn't living in your neighborhood, but the reason we're different from other countries is because we have a constitution which we should all honor, and it applies to everyone, even people who are committed to an institution. And what happened wasn't right, and you should stand up for what's right. And the jury returned a verdict that the institution through the guard, violated his Fourth Amendment rights.
One last question, and I think we're about out of time. I know it's important to thank the judge and the jury. Do you do anything special when you thank the jury? I know it depends on the case. Jay, what do you do?
No, just thank the judge and jury for their time, and we sure appreciate it. And we know you spent time away from your work and your families, but this is why the justice system works. So we have citizens who are willing to volunteer for this, and it means a lot.
I say that Abraham Lincoln said, after being a soldier, the most important thing a citizen can do is be on a jury. And we appreciate it, and that's what keeps our country running.
Lori, do you find in your consulting work that thanking the jury and doing things other than thank you for being here today? Like Jay and Neville are both getting great examples of something a little more personal, like they're making it personal to the jury. Hey, you're not saying, hey, thanks for coming by. You're saying, hey, you really contributed here today, and this is part of our system, and this is why it's so important. Lori, do you find that helps?
I think it helps, but it also helps to add to that, to remind them the promises they made in jury selection and when they were sworn in, to the extent that you've asked for certain commitments for them to now uphold them.
Well, this was great, and I'm always, Lori, I was thrilled to meet you, and I know I've worked with Jay and Neville before, and I so appreciated your insights and things like that. I'm taking my own little notes here, and thank you. And for those of you who are viewing today, we're going to have another presentation that all three of these fantastic speakers have generously agreed to speak at, which is appealing to cross-generational jurors. So stay tuned, and thank you so much.
Thank you.
Thank you.
Bye-bye. Thank you.
I know.